Sexual harassment training for employees. Sexual harassment training is not required under federal law. However, many states have enacted legislation specifically requiring sexual harassment training. Even if not required in a state, the Supreme Court's landmark decisions in two 1998 sexual harassment cases, subsequent court decisions, and Equal Employment Opportunity Commission guidelines make it clear that sexual harassment training is essential. It is essential that you know how to recognize sexual harassment and how to respond and prevent it. This sexual harassment training provides you with that knowledge. Offering this training also helps us raise your awareness and understanding of conduct that violates the DSI anti-harassment policy and can have profound impact on employees in their careers. Sexual harassment glossary. Harassment. Any unwelcome, aggressive, or disruptive behavior, pressure, or intimidation. Harassment can be verbal, visual, or physical in nature. Hostile work environment. Any pervasive conduct in a working situation which a reasonable person would consider intimidating, offensive, abusive, or hostile. Leering. Looking or gazing at someone in an unpleasant, sexual, or malicious way. Offensive conduct. Any unwelcome behavior which a reasonable person would find objectionable. Examples include unwanted verbal or physical sexual advances. Leering. Offers of reward at work for sexual favors. Threats for actual reprisals for declining sexual advances. Making offensive remarks about a person's appearance, manner of dress, or parts of their body. Telling sexually oriented jokes. Gesturing sexually or displaying sexually suggestive images in public view. Any touching that makes an employee feel uncomfortable, such as slaps or pats. Intentionally rubbing against another person's body, pinching, or impeding or blocking movement. Employees who complete this training will understand the following. What is sexual harassment? Why it is important to prevent sexual harassment in our workplace. Retaliation. Our policy and procedure on sexual harassment and your responsibilities. The Equal Employment Opportunity Commission, also known as the EEOC, defines sexual harassment as any unwanted or unwelcomed visual, verbal, or physical conduct of a sexual nature, request for sexually oriented special favors, or exposure to offensive conduct or content. Sexual harassment can occur in a variety of ways, including verbal, written, physical, or visual. Other verbal or physical conduct of a sexual nature that affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. Examples of sexual harassment include verbal or written conduct such as derogatory comments, slurs, notes, messages, invitations, emails, or jokes. Visual conduct such as leering, gesturing, sexually suggestive pictures, posters or calendars, internet or email materials that contain sexually explicit or suggestive pictures, cartoons, or pornography. Physical conduct such as unwelcome touching, hugging, blocking someone's path in an inappropriate or sexual way. Sexual harassment is not just about the law. Showing respect for others, regardless of any kind of difference, is always the right thing to do. The two forms of sexual harassment are quid pro quo. This is Latin for this for that, or something for something. And hostile work environment. Quid pro quo, tangible employment action against the victim, involves monetary loss or change in job. For example, Mary Smith received smaller pay increase based on performance than other employees with similar performance because she refused to go out with her supervisor, John Doe. Hostile work environment. Speech or conduct that is severe and/or pervasive enough to create an abusive or hostile work environment. For example, Mike Maloney is leering at and intentionally brushing against Sally Davis. In addition to speech and/or conduct, hostile work environment covers explicit or suggestive items that are emailed, texted, electronically provided, or displayed in the workplace that interfere with job performance or that create an abusive or hostile work environment. For example, Jill Jones texts and instant messages her coworkers with sexually explicit jokes and pictures. Who can commit sexual harassment? Employees at all levels, customers, vendors, suppliers, or visitors, members of the same sex or opposite sex. Who can be a victim of sexual harassment? Individual or individuals targeted by statements or actions, bystanders, third parties, or witnesses not directly targeted. Third-party complaints are fairly common, especially where 2 or 3 people frequently joke around with each other and are unaware or just don't care how their behavior affects others. Harassment and discrimination laws protect everyone in the workplace. If your behavior is inappropriate and offends even one person, your supervisor will have to ask you to stop. Unlike the free speech rights you have in other aspects of your life, it's simply not your right to make discriminatory or harassing comments in the workplace. The employer is responsible for providing a workplace free from discrimination and harassment, regardless of the problem. The law requires employers to take all reasonable measures to protect their employees from illegal conduct in the workplace. The law recognizes that some very mild behavior or conduct actually doesn't violate the law. The U.S. Supreme Court in one case even noted that sexual harassment law isn't meant to set a civility code for the nation. The best test to determine if something may be sexual harassment. Ask yourself, could this conduct offend a reasonable person in this person's situation, taking into account the setting and context of the behavior? If a reasonable person could find the conduct offensive and the complainant did find it offensive, then it has crossed the line and should cease. Why is it important to prevent sexual harassment in our workplace? Sexual harassment harms us all. The most important part of our corporate values is to ensure all employees are treated with respect and dignity. Engaging in, condoning, or not reporting sexual harassment is in direct conflict with our values. We want to remain in compliance with Title VII of the Civil Rights Act, which prohibits sex discrimination, including gender identity, change of sex, and/or transgender status. We want to remain in compliance with similar state civil laws and fair employment laws. We also want to prevent sexual harassment in our workplace because it adversely affects workplace productivity. It leads to increased absenteeism, leads to high staff turnover, leads to the departure of valuable employees, increases chances of litigation, and establishes a poor public image of the company. Is it sexual harassment? True or false? If an employee repeatedly makes sexual jokes near the cubicle and no one involved in the conversation complains, the company bears no responsibility. False. Such behavior might be okay at a private happy hour if no one there has a problem with it. However, it's totally different if it occurs in an area where everyone can hear it, like a break room, conference room, or open workspace. If this happens, the jokester's manager must take appropriate action and respond to such inappropriate behavior and/or immediately elevate this matter to the attention of HR to avoid a potential hostile work environment. True or false? A single complaint doesn't warrant an investigation by human resources. False. Although a behavior isn't legally considered harassment unless it is shown to be pervasive, HR must take every complaint seriously and consider the likelihood that the initial grievance could be the tip of the iceberg. The EEOC will make the decision about whether it's pervasive, but we can't wait until it's pervasive to take action. If you witness harassing behavior, immediately raise it to HR. HR will proceed by conducting a thorough investigation. HR will ask the person who complained to share the details about what happened and who may be aware of the incident. HR will interview all witnesses. Once all evidence has been gathered, HR will also get the accused person's side of the story. After collecting the accused person's statement, HR can disclose the evidence and consider all facts and apply appropriate consequences as necessary. True or false? HR may need to tell an individual if his or her physical gestures, such as a tight hugging and shoulder massages, are making others uncomfortable. True. This falls under whether or not a reasonable person finds that behavior acceptable in the workplace. It's about having spatial awareness. While some employees could opt to tell a coworker directly if they don't like the way someone touches them, not everyone feels comfortable doing that, and thus may prefer to bring their concern to HR. It's HR's job to let the offender know that the behavior is unwelcome. There's a difference between giving a hug to say hello and rubbing someone's shoulders that is unwelcome. True or false? If my intentions were good, for example, I meant to compliment someone on how great they looked, there is no way my conduct could violate my employer's sexual harassment prevention policy. False. Harassment is seen through the eyes of the victim, not the intentions of the harasser. So even well-intentioned comments could offend and violate the policy. True or false? It may be some form of harassment, but it cannot be sexual harassment if both the offender and the victim are of the same gender. False. Men and women can both sexually harass, and it doesn't matter what gender the victim is. True or false? If most people find a comment amusing and inoffensive, then the one person who is offended does not have a right to complain about harassment. False. Harassment and discrimination laws protect everyone in the workplace. Retaliation. Retaliation is an adverse action taken against an employee because he or she complained of harassment or discrimination or participated in an investigation. Adverse action includes demotion, discipline, termination, salary reduction, negative performance appraisal, change in job duties, or shift assignment. Anti-discrimination laws prohibit employers from taking adverse action against employees for asserting their rights. Employees should never fear any punitive action or retaliation for filing a legitimate complaint of sexual harassment. Employers are free to discipline or terminate workers if motivated by non-retaliatory and non-discriminatory reasons that would otherwise result in such consequences. However, an employer is not allowed to do anything in response to EEO activity that would discourage someone from resisting or complaining about future discrimination.